Good afternoon, everyone. Thank you for joining us for today's Lunch and Learn. I'm Lauren Smith with the International Franchise Association, and we have a great 30 minutes lined up for you. Before we begin, I would like to remind everyone that we're recording today's webinar and will make it available later this evening on community.franchise.org. If you have any questions for today's speakers, please add them to the Q&A box and they will be addressed toward the end. Today's topic is the latest on junk fees for restaurants, and it is brought to us by Greenberg Traurig. Here to provide today's discussion is Alan Greenfield, Adil Khan, and Riley Lagesen. Thank you all for joining us today, and thank you to Greenberg Traurig for sponsoring today's Lunch and Learn. I'll go ahead and turn things over to you.
Thank you, Lauren. Appreciate that. So today we're going to be talking about the big picture of SB 478 and the latest developments around California SB 1524 and what it means for restaurants and food operators. We're also going to be talking today about risk mitigation that restaurants and franchisors can take with respect to these California bills. And lastly, we're going to touch on the recent FTC guidance for what they're calling junk fees as well, and what that means for franchisors. I was asked today to reiterate that our positions and what we say regarding these bills and FTC guidance in particular does not reflect the opinion of the IFA, and it's simply our discussion here of these panelists. And so I would like to reiterate that. And I'm going to turn it over to Adil to start off about SB 478.
Great, thank you, and good afternoon and good morning to everyone. Can we get to the next slide? So this was just an outline, an overview of what we'll be talking today, but I'll pick up on the next one, slide 4, please. So let's talk about the big picture. Now, SB 478 and SB 1524, which we'll get to, are amendments to a California consumer protection statute called the Consumer Legal Remedies Act, the CLRA. California Civil Code Section 1770. Now, SB 478 was passed last October, and it went into effect on July 1st of this year. So that's what I will be focusing on. SB 1524 also passed a few months ago, and Riley will be covering that later in this presentation. Now, the CLRA and these amendments apply to almost any sale or lease of most goods or services that are for a consumer's personal but not commercial use. So that means we're generally focused on claims by customers or claims that the state or prosecutors might bring on the customer's behalf. In other words, this would not cover direct claims by a business. So for example, franchisees making claims against franchisors, that would not be covered by the CLRA. But it would cover claims by customers against the franchisees and franchisors. Now, these statutes, these are price transparency statutes. They are not price control measures. So that means businesses can charge whatever they want as long as it's compliant and not misleading. The goal here is to avoid so-called bait and switch tactics, where businesses lure customers in with attractive prices, but then include surprise or hidden or confusing fees at the end that result in an unavoidable higher sticker price. So generally speaking, SB 478 makes it unlawful for businesses to advertise or list a price for a good or service that does not include all mandatory fees or charges. That's a lot, so let's break that down. And I think it's helpful to break that down by talking about the exceptions. Now, the exceptions are very limited. The only statutory exceptions are certain government taxes and shipping costs. And shipping costs are very narrowly defined as postage or carriage charges that will reasonably and actually be incurred to ship the physical good to the customer. Now, the third carve-out is for goods and services that are not mandatory. So they're truly and reasonably optional. So for example, if you're ordering food online, pickup is often no extra charge, and delivery is an optional service. So it's okay to have a separate delivery charge. But it gets tricky with other fees like service fees and technology fees because those are often unavoidable and thus they're considered mandatory. Now, there is a final carve out for restaurants, bars, and food services, and that's found in SB 1524, which again, Riley will be discussing. Next slide. The potential consequences for non-compliance are very important to understand. Now, in private litigation, the real risk is consumer class actions. And the CLRA allows for a broad range of remedies in litigation. So first, we have actual damages. Now, the question is, what could damages be when everything is truthfully disclosed and knowingly paid? It's an open question, but generally, we assume it's probably approximated by the aggregate of the hidden or so-called hidden fees, and those can add up quite significantly, whether it's $1.99, $3.99, $4.99, whatever the case is. The second form of relief is restitution, and this means giving back what was wrongfully taken. Again, that's probably best approximated or capped at a refund of this so-called hidden fee. There's also the availability of punitive damages. So these are something that the courts can add on top to punish bad conduct and make an example for the industry to learn from. It's a high bar, but it's a serious consideration. There's also injunctive relief. So other than money, being forced to do or refrain from doing something. So this could be, for example, changing business practices, a court order for corrective advertising, that kind of thing. And then, of course, there's attorney's fees, and those can be quite high in class actions. Hundreds of thousands of dollars are not uncommon, could be even higher. Attorney's fees can be in the millions, depending on the size of the case and the size of the value being delivered to the class. Now, the government can also enforce the CLRA through public prosecutors at the state or county level, and they can piggyback off of laws, other consumer protection laws. So in California, the unfair competition law, the false advertising law, etc. And it's important to note that in California, it was the AG's office who was a sponsoring org for SB 478, which indicates they are clearly invested in this. So in addition to the remedies we discussed, if the case is brought by a prosecuting agency, they can also seek civil penalties of up to $2,500 per violation, plus disgorgement of what was wrongfully obtained. So clearly, this dramatically increases the exposure risk. And again, the fact that the AG's office was involved in the legislative process here shows that they are very interested and highly motivated towards enforcement. Let's advance to the next slide, and I'll hand this off to Riley.
Thank you, Adil. Let's take a look at the big picture. We are living at a time where there is increased scrutiny on pricing practices nationally, at the state level, and the local level. So many of you may have read about some of the lawsuits that have been settled, pricing discrepancies, online pricing versus in-store pricing, some pretty significant settlements with restaurant brands over the last year in that area. And then the increased emphasis on what are often called junk fees. We've heard about that quite a bit in terms of some federal activity, as well as a number of states, of course, California really leading the charge with SB 478 in this area. And what it signals to businesses, and especially in the restaurant space, is that we can expect an increasing amount of attention, especially in the private litigation area, on those that are engaging in using mandatory fees, surcharges, or relating pricing related practices that draw attention to what the business is doing. And as Adil said, in terms of resolving the big risk, these are incredibly difficult and expensive to resolve. If you've ever been subject to a lawsuit, not even a class action, but just a single claim plaintiff trying to negotiate the other side with an attorney threatening a class action, you're spending a lot of money and time on attorney's fees. You're probably looking at a very significant settlement. And that's the lens at which we look at this, because the restaurant industry obviously is under tremendous pressure around the nation, especially in California. we see SB 478, 1524 as really the second punch of a 1-2 punch this year, with the FAST Act that was enacted earlier this year, which rose the minimum wage to $20 an hour for covered businesses, as well as pushing wage pressure throughout all businesses in the state. So attention to this is incredibly important for those that are engaged in business, not just in California, and it's not just franchisees that are covered by this. Franchisors that are implementing mandatory surcharges in their practices that are being passed along to consumers are also at risk. So all involved should be taking a careful look at business practices and evaluating the best plans moving forward. So SB 1524 was a reaction to SB 478. So the California Restaurant Association and others worked really hard to create an exemption of sorts to the applicability of SB 478, because when 478 was published, the Attorney General's office came out with an FAQ. And in that FAQ, it basically upended a lot of common business practices that restaurants have had since the beginning of time. So consider mandatory gratuities. So a mandatory gratuity where it's common to go into a restaurant if you have a big party, of 8 or more, or if you're booking a banquet, there's a mandatory gratuity that's put on it. Under the FAQ, those gratuities would have need to been rolled into the menu price. And from a practical standpoint, that could be really hard to do. In a lot of these circumstances, really confusing, a lot of area for risk, and uncertainty. And it also outlawed what has been very popular, especially on the West Coast over the past 10 years, is the use of additional mandatory surcharges. We started seeing this over 10 years ago as wages were rising in response to the fight for 15, especially up and down the West Coast, Oregon, Washington, California, and in New York. We saw the adoption of mandatory surcharges saying, to offset rising labor costs, we charge 3%. To also as an alternative, for employees, to tip out the back of the house for those using tip credits in states where you can't have a mandatory tip pool, and also share with the back of the house. We saw these being adopted to share with the kitchen or for other purposes. Sometimes money would go to the house, sometimes it would be shared with employees, giving the business discretion over how to utilize these. Not surprisingly, we've seen a lot of litigation, from between the time these were adopted until now, around the use of surcharges and fees. And so what 1524 really does, it really kind of crystallizes what has been ongoing recommendations for businesses about the use of these fees for a very long time. And so SB 1524 is intended to apply to the restaurants and bars, as you can see in this slide, and other food service providers, including some grocery related food service and others. And it exempts these businesses from the applicability of 478 to the extent they are meeting the requirements of SB 1524 in terms of the disclosure of mandatory surcharges and fees. So next slide, please. Oh, take it back one? Okay, so here's the text of 1524. Move it ahead one slide, please. Okay, and it breaks down the components of what a business must do to fit within the SB 1524 exemption. And so a mandatory fee or charge, will be exempt if it meets certain requirements. And we're going to talk about a couple of those requirements right now. Next slide, please. So in order to be exempt from SB 478, the elements are broken down at the bottom of this slide. So the mandatory fee or surcharge needs to be clearly and conspicuously displayed. And what this has historically meant in terms of guidance provided to operators using them is that the customer needs to be aware of these fees or surcharges prior to making the purchase. And as much advance notice that you can provide to a customer before making this purchase, the better. So over the years, we've seen obviously placing on menus and placing on menu boards and areas in which the customer is going to be informed about these before making that purchase decision. We defended a class action several years ago where a client had disclosures in various places on menus and so forth, but there wasn't a disclosure at the bar. And so some patrons who had bought alcohol, at the bar said they weren't aware of the surcharge, turned into a class action, very expensive to resolve, even though in other places on the premises, the surcharge was clearly displayed. So businesses are advised to be very careful about all points of information provided to consumers pre-sale. There's clear and conspicuous disclosure. Also, explanation of purpose, and also that it's on any advertisement, menu, or other display that contains the price or food and beverage item. We'll move on to the next slide.
Riley, we have a question. Do we want to wait to the end, or do you want to?
Yeah, why don't we?
answer it on this
We
topic?
should have plenty of time at the end, so why don't we reserve to the end? We just talked about clear and conspicuously displayed, and there's also a requirement in the statute that as of July of 2025, there's a statutory definition for clear and conspicuous disclosure, and that is here in the slide, and basically a larger type than the surrounding text to really draw it out to the customers. Next slide, please. With an explanation of the purpose, and this is a slippery area for a lot of operators, because you've probably been into a restaurant and you've seen one of these mandatory surcharges presented to you, hopefully before purchase, but sometimes after, where it says, oh, we charge a service charge of a mandatory service charge of blank. Okay, service charge, that can mean different things to different people, and service charges are used by operators differently. Some may use it where 100% goes to the employees. Some may use it where 100% goes to the house. Some may use it where there's a sharing, determined by the business, is how they allocate proceeds from the surcharges. And just one example of where clarity is very important in terms of describing the purpose, because if there's any ambiguity in it or anything that may be considered by a private litigant plaintiff's counsel to be false, deceptive, or misleading, odds are it could become a problem, and a significant one in the future. So it's very important to be thoughtful about explaining the explanation of the purpose. And in SB 1524, it's a requirement for the exemption. So we have clear and conspicuous disclosure prior to sale, and this goes to whether it's in written form, digital, online, all this kind of stuff. And Adil's going to get to this in the next slide to talk about this a little bit further. But we're going into uncharted territory right now, especially as part of this third element here. So in terms of where we are today and best practices, and there may be further guidance coming from this, and a lot of this is going to shake out through private litigation as to what the best practices are. But in order to protect oneself, clear and conspicuous disclosure, explanation of purpose, and then I'm going to turn it over to Adil to talk about the third element.
Thanks, Riley. So like Riley mentioned, there's a lack of clarity on what the statute means and who it covers. And I'm talking here about 1524. So for example, are businesses that offer no in-store dining, but exclusively provide delivery and takeout options considered restaurants? It's unclear. Does the disclosure need to be included on every single place an item price is listed? I mean, wouldn't that just require a fine print everywhere that eventually gets ignored precisely because it becomes ubiquitous background noise? Maybe. Disclosures on websites and mobile apps, those might make sense, but how would this work for in-store displays, particularly hand-drawn ones that might change daily and don't have a whole lot of real estate for disclaimers? All of this is sort of a bit unclear based on the text of the statute. Next slide. So much remains unknown, and these questions, the limits of the statute, how it's interpreted, a lot of this will need to be tested in the courts. And hopefully for you, you're not the defendants who are making those arguments and testing those limits. The other option is maybe the legislature takes further action here, but I've not seen any indication that that's forthcoming. So for now, businesses should consult with legal experts about their current practices, plans, and questions. And they should also look at their contracts with their service providers, franchisees, franchisors, etc., to see who's responsible for what and who may have certain rights. So just for example, let's say you have a consumer class action against a franchisee. Now, even if your franchise agreement disclaims any liability, for the franchisor, if the franchisor controls the user interface and what fees get charged, and the franchisor is the one that has the contracts with the digital service providers or the POS service providers or the delivery service providers, then you might have an equitable indemnity issue. So even if your contract suggests you have no liability, fairness might dictate that maybe the franchisor is on the hook because the franchisee could not have done anything to actually insulate itself from liability. So these are all complicated questions, and they will be fact specific and situation specific. So the goal of this presentation is to flag some of the issues for you to consider so that you can then consult with legal counsel. I'll hand this back to Alan for the next slide.
Thank you. So this portion of the topic, although called junk fees, is a little bit different. Last month, July 12th, the FTC came out and issued staff guidance on undisclosed junk fees. According to the FTC, this guidance resulted from in response to comments that were submitted in response to FTC's request for information related to franchisors' business practices, as well as an event that Chairwoman Khan attended with franchisee associations. And in response to these comments and this event, apparently the FTC has been informed that there's a common practice of franchisors imposing undisclosed fees on franchisees. And so this guidance that was issued by the FTC makes clear that all fees that are charged to franchisees must be included in the franchise agreement and disclosed in the FDD. And if not, a franchisor could be in violation of both the Franchise Rule and FTC Act. According to the staff guidance, a lot of these fees are being imposed in operations manuals in particular when these fees were not otherwise reserved and disclosed. Next slide, please. Now, as a franchise practitioner, I will tell you, none of this is new from our perspective, right? When clients are looking to impose new fees to help offset costs, similarly to what Riley and Adil was talking about in this presentation, franchisors have looked to pass on that cost to franchisees when they're providing especially additional services to these franchisees. Common fees that come up in this respect are new technology fees and supply chain fees in particular. We've been involved with and seen a lot of this over the more recent years. I will tell you that typically we talk about, and most franchise agreements already reserve the right to, especially to include and to impose new technology fees. Even if they don't have a specific amount, the franchisor reserves the right. And more often than not, right, you see that disclosed as you should in the FDD. As for supply chain fees, that has become a trickier issue that we see where, franchisors are looking to help offset these additional services that they're providing primarily as a result of COVID. And a lot of these fees, right, the key we've talked about with, franchisors is to, if we don't reserve the right and otherwise have it in the franchise agreement and disclosed in the FDD, it's to make these fees optional for existing franchisees and roll them out in future agreements. Again, that type of guidance is not new. And so the fact that there's this common practice according to the FTC of franchisors imposing fees in the operations manual that have not been reserved or addressed in a franchise agreement, and are undisclosed. Again, in our, in my opinion, it's much ado about nothing that these have already been rules that franchisors are generally following. So some takeaways, what this means for franchisors: be sure to reserve, to the extent we can contemplate possible additional fees where things are headed, like technology and supply chain. Reserve that right in your franchise agreement. Also, be sure to reserve a right to increase those fees or to modify those fees. And lastly, we would encourage franchisors to review their documents, the franchise agreement, operations manual, and their practices, to make sure they are in compliance with the franchise rule and FTC Act, because as we're seeing, the particular, this FTC administration has become more hands-on than what we've seen in prior years. With that, we have about 5 minutes. We would like to take this time to answer some of the questions we received. And if anyone has any additional questions, please feel free to type them in this question and answer box below. I'll start off. I'll ask for the group here. This is for Riley and Adil. All the questions so far are for you, for the two of you. First one, how does 1524 impact businesses that charge a fee for credit cards as opposed to paying in cash?
Sure. So I can start off and then hand it off to Riley. So under the SB 478 analysis, so that's before you get to the carve out for restaurants, a credit card charge generally will not be seen as a mandatory fee, because you generally do not have to pay only by credit card. So particularly for in-store transactions, cash is often available. But if you have an online purchase and credit card is the only way somebody can pay, then the Attorney General's guidance says, well, in that case, it is mandatory, because there's no way a customer can avoid it. And therefore, it would need to be built into the menu price, right? Now, and it should not be just a fee that's on the final kind of subtotal line item, at the checkout screen. Now, under 1524, Riley can talk about this in more detail. If you're covered by 1524, you're a restaurant, bar, etc., and you meet that 3-step set of requirements, then you could insulate yourself. Riley?
That's exactly that. Yes, if covered by 1524, just following the 3 elements that need to be met, if indeed, and even if it's questionably not mandatory, even if it's, to err on the side of caution would probably be the best path. If you're any charge that is almost undoubtedly going to be paid by a customer just to avoid a demand letter or a potential lawsuit from a private litigant, best to err on the side of caution and follow the elements of 1524.
And Riley, to piggyback off that, if that cost has been included in the menu price, how does that factor in someone that's paying by cash? Well, I guess that'd be impossible for online, so that would address that.
Yeah. If you build it into the menu price, it solves all the problems. So this is for those that want to use a la carte, separate mandatory charges or quasi-mandatory charges on an ongoing basis. And not to go back into the details of the FAQ from the DOJ in California, but there are a lot of gray areas here, as Adil mentioned too, that need to be explored. Is it mandatory? Is it essentially mandatory? There's a spectrum of analysis that goes on with restaurants and other businesses here. So just very important to be aware of the criteria and the applicability.
Yeah, and in fact, the legislative history and the guidance from the Attorney General, it's very clear what they want businesses to do is build as much into that item price or that menu price as possible. So generally speaking, that would be the safest route. The problem is that creates some business issues, because you can't have, you can't list a menu price of, that's too high and goes against, consumer expectations. So that's the pull.
So another related question, does this apply to franchises that own a mobile ordering app like for, when charging a delivery fee, for example? And if it does that fee need to be displayed at the beginning of the transaction?
Well, it's interesting, and I'll let Adil talk about this, but 478 excluded bona fide delivery fees from being required to be rolled into the menu price because that's for a separate service. Adjacent to the delivery fee issue, also pricing on delivery, because there's been a lot of activity. If you are charging your franchisees, or you as a franchisor are requiring higher prices for delivery purchases on menu items as opposed to in-store pricing, there's a lot of brands that have faced litigation in this area and some pretty significant settlements. And so you're seeing a lot of best practices play out right now with brands. Before you even order, you got to click on something that says, customer, there's a delivery fee. We charge higher prices for online orders than we do in store. If you want a lower price, you can go in store and pick it up yourself, essentially. So there's a lot involved here, but delivery fees are expressly excluded from 478, bona fide delivery fees as a separate charge for a different service.
That's exactly right.
Another question.
Oh, I was just going to add, yes, mobile representations and statements made on mobile apps are absolutely covered. Optional services like delivery do not need to be built into menu price. But again, you might need to consider, are you only providing delivery? If you're a delivery only business, then there's an argument to be made that that is mandatory because there's no way to avoid that. So again, a lot of this is really fact specific, and you would really need to sit down with counsel to talk about all the details.
So on that note, facts specific here. What about if a customer calls in an order and is then going to go pick up the item? Should there be a script that people need to, that your employees need to read? So that way it's disclosed on the front end before a customer goes and pays? What do you recommend there?
So generally speaking, customers are going to be looking at something in writing before they place a phone order. So I would really focus on those written, whatever you have online, on the mobile app, the printed menus, etc. If they ask what's the price by phone, then yes, you should treat that as if it's all those statements, the verbal, oral statements are covered by these statutes.
Would absolutely recommend pre-purchase disclosure for the elements. And a great question, because transactions do happen by phone. Happened to me recently. I called in for a hotel reservation, and a bunch of fees came up at the end of the call that weren't disclosed, and it was a big surprise. And so we're going to see a lot more legal activity in this area across a lot of businesses, but especially restaurants should really pay close attention to this.
And if companies are developing scripts and talking points, you really should consult with counsel, because on the one hand, having a script could help insulate against liability because you're making sure things are done right. On the other hand, uniform scripts and talking points provide additional considerations from a class certification standpoint. And as a class action lawyer, that's always something I'm thinking about. So again, really consulting with counsel would be very helpful.
So two more questions we have here. One is, does SB 478 or SB 1524 distinguish between fees charged by the franchisor or the restaurant or third-party fees? So does it cover third-party fees?
Well, to the extent they're passed along to the consumer as a mandatory charge, yes. There are certain in the statute of 478 with respect to third-party delivery fees. Those are exempted from the statutory language of 478, at least based on the DOJ's May 2024 FAQ. But again, these are all very fact dependent and specific. So say best practice, anytime a business is planning on passing along a mandatory fee or surcharge to a customer, to really think through all of these different elements to best mitigate risk.
There are two more questions. I can answer one, but the other one here says, we understand that delivery is optional separate. However, are fees included within the delivery fee structure? Examples: service fees, geographical fees charged by delivery aggregators, long distance fees, small cart fees, etc. Are those considered mandatory? And does rolling all those fees into a single delivery fee without that breakdown, does that help mitigate the risk?
Sure. So it sounds to me, out of those examples listed, it sounds to me like those are not avoidable, right? A customer cannot meaningfully avoid something like their location, right, where they're ordering the delivery to. So all of that would need to be looped into either the delivery fee or the menu price. And again, clear, truthful, accurate disclosures are always going to be helpful. So even if you are loading up a lot into your delivery fee going forward, that maybe before you wouldn't have, and that delivery fee is actually ballooning a bit, an explanation there of what's included in that delivery fee could be very helpful and could mitigate risk.
All right. And the last question here, we touched on in the presentation that talks about how does SB 478 impact the franchisor to franchisee relationship when it references to a consumer? Does California define consumer include a franchisee buying a product for business purposes? Well, the first part we touched on. The first part is that, if the franchisor is charging fees, for example, some franchisors operate their own POS and computer systems that franchisees are required to use. There, it would impact the franchisor because it's the franchisor charging this fee to consumers. If the franchisor is charging a fee to the franchisee, SB 478 and 1524 do not apply to that relationship. They're not consumers in that respect. But the second part of this question is asking, do either of these apply to where a franchisee is buying a product from the franchisee for business purposes, right? Franchisors that sell proprietary food products, as an example. Would the franchisee in that respect be considered a consumer? That's for you both.
Yeah, generally speaking, no, because the franchisee is buying that good or that service for business purposes, so would not be considered a consumer. But let's be very clear here that today's discussion, at least for me and Riley, has been about the CLRA, but California does have several other consumer protection and false advertising and unfair competition statutes. So there could be legal theories there that a franchisee could come up with that fall outside of just this one statute, the Consumer Legal Remedies Act.
And also two quick, I think, important points on this question. Even if the franchisee is the one charging the mandatory fee, maybe it's not being imposed by the franchisor, but the franchisee is, and they get sued, there's a very good chance the franchisor will also get named in the lawsuit. And there will be an indemnification issue to deal with that is time consuming and expensive, that is better off not dealing with. The second very important point is the cost of defending and resolving these cases is enormous, especially in light of the scale. You can find a $100 claim that turns into, a settlement of over $100,000, including legal fees and everything else in California. And so it impacts the relationship in that if the franchisee is defending a whole bunch of lawsuits that they can't afford to defend, and they're also dealing with increased wages and inflation and decreased traffic and everything else, it turns out to be a very unattractive economic scenario where you're going to find a lot of franchisees that may potentially not be able to stay in business. And then that obviously impacts the franchisor's economics in an adverse way. So very important for franchisors and franchisees to be aware of this, and have some best practices in order so franchisees can get the information they need to be compliant.
Thank you. And so that answers all of our questions that we received, and we've gone about 9 minutes over, so our apologies, but we wanted to make sure we answered your all questions. So we'll turn it back over to Lauren and IFA.
Thank you. Thank you so much, Alan, Adil, and Riley. We really do appreciate it. Again, this webinar was recorded, and along with the presentation deck will appear on our website early this evening. You'll be able to find that at community.franchise.org. Thank you very much again to Alan, Adil, and Riley, and the Greenberg Charg team. And again, thank you to everyone for tuning in. Have a great rest of your day. Stay safe and healthy. Bye.
Thank you.